Going live now. Excellent. Okay, so we're live on Facebook, YouTube, Instagram, TikTok, all the platforms. Guys, if you can hear me and see me well, please just type in the chat box USA. You can also drop the emoji of the US flag. So type in USA or drop the emoji in the chat box, and then I can see that you guys can hear me and see me very well. Type in USA, USA, USA. We're going to get started momentarily. All right, so I'll be taking your questions as well very soon. So feel free to drop the questions after you type in USA or drop the USA flag. Okay, let's get started. There's been a lot happening in US immigration world, and today we'll be discussing some of the recent happenings and what it means for some of us. Let me put this a little down. Okay, there you go. Okay, so we'll discuss what's going on in Florida. We'll discuss some of the recent arrests as well. We'll discuss some of the key offices that have been closed down. The OIDO CI's Ombudsman office, and then the CRCL office as well. Those offices that are in charge of overseeing immigration detention and USCIS errors and things like that, moving cases along when there were delays. And then the pause or the temporary stop in processing of some green card applications as well. Okay, so that's what we're going to be discussing today, and then we'll close out with an interesting story. Very, very interesting story. So stay tuned to the end, and then we'll take your questions and do our best to answer as many as we can before we leave. Okay, let me share my screen with you guys here on YouTube, LinkedIn, and Facebook. If you want to see the screen, then you can join in from those channels. Okay, we're going to be looking at the let's see. As always, all these documents we're going to be using have been opened, but technology, the wonders of technology, one of them has suddenly disappeared. So let me try to pull it up again, and then we can continue. Let me put this. I'm sorry. So we're going to be looking at Florida. What's going on? Florida, over the last few months or years, it's become one of the states with the harshest US immigration policies in the United States. So it's no surprise that many of the immigrants, especially the undocumented immigrants, have left the state. And there is a major problem that they're facing currently. Okay, there you go. Let me pull that up now. All right, so on my screen, you will see the Senate Bill 918, the Florida state. Let me make sure that you guys can see. Okay, you can see a bill on my screen. It's called SB 918. We posted about it across our social medias, and we were discussing what's going on in the state of Florida. Now, the U.S. Chamber of Commerce, this was December 2024, the U.S. Chamber of Commerce actually reported that America was facing a labor shortage crisis. And it named Florida as one of the states where the situation was severe or is severe. And they could, for every 100 open jobs, they could only count 53 available workers. So half the time, businesses could not fill available roles or available jobs. Half the time, you couldn't find somebody to occupy a vacant position. So the unemployment situation in Florida was very dire as of December 2024. So you can imagine that it's even more dire now with all the rules going, all the laws, all the enforcement actions, things that are being instituted. It's not surprising at all that even more people between December and March may have fled from the state of Florida. So that statistic that was given by the US Chamber of Commerce that was reported 4 months ago has likely even worsened. And Florida was one of the states where the situation is very severe situation, labor shortage crisis. And many of the industries had been reported, to be struggling with filling up positions: construction, farming, manufacturing, agriculture, many of the industries. And so, in response to this crisis, the Florida's Republican governor, he's a Republican, Ron DeSantis, he came up with a brilliant idea. And the brilliant idea is that they are going to resort to children to fill up these vacant positions. And so they've had, the state labor laws that has rules on when a child should work, when a child should not work, time restrictions, as well as other restrictions to ensure that children were in school, were taking the needed rest, and were not being taken advantage of by employers. These rules were in place to protect them. If you look at the Senate bill that I've just shared, it is they advanced this bill on Tuesday, the state legislature, and they actually voted on the bill. The bill apparently passed through Senate Commerce and Tourism Committee, where they will review. And there were 5 votes in favor of loosening child labor laws in Florida and 4 against the bill. The bill is supposed to pass through a couple of other committees before it will be put to a vote with the full Florida Senate. The final outcome will be made known. Okay. Now, if you look at the bill I've just shared, where you see the cancellations are deletions in the bill, and the underlined sentences are additions. You'll see that they've now deleted some of these things, that some of the restrictions for 16-year-olds and 17-year-olds, that they shouldn't be employed before 6:30 a.m. or after 11 p.m. That has been deleted. Okay, that has been deleted. That amendment, they're trying to amend that law so that 16-year-olds and 7-year-olds can work in the night. They don't have any time restrictions about, work only between 6:30 a.m. and 11 p.m. when school is session for the following day. Even if school is session for the following day, you can work throughout the night and go to school. That's what the bill is proposing, because it's deleted that restriction that was there. There's a number of other deletions and restrictions, but among some of the most striking, children as young as 14 years old. So if you look at, I believe section 4A, it says that minors 14 years and 15 years who have graduated from high school or they've received a high school diploma, for example, they will not have some of these restrictions. They will be allowed to work in the night. During night shifts, they'll be allowed to, work even when school is in session the next day. And that's also for children who are within the compulsory school attendance age limit, who hold a valid certificate of exemption issued by school attendant, and children who they have an economic necessity or family emergency, and they are enrolled in a public educational institution. So they have a hardship. If they have a hardship, then the restrictions that are contained in subsections 1, 2, and 3, talking about, oh, you cannot work between a certain time, you cannot work when school is in session the next day. Those restrictions will not apply to such children who have economic hardship. Then, thirdly, children like minors, 14-year-olds, 15-year-olds who are in a home education program, who are enrolled in an approved virtual instruction program. For example, these restrictions did not apply to them. They could work, there were no time limits on how long they could work, how much they could work, even if they had to, attend classes or school. Okay, so they could work for more than 30 hours in any one week when school is in session. So they can work more than 30 hours, whatever that time looks like for them. And, the person who proposed this bill is Senator Collins, and he believes that his argument is that they want to put power back in the hands of parents. Parents should be responsible for determining what's right for some of these children. But it's very interesting because if you live in a household where parents are undocumented and the children, let's say a 15-year-old, a 14-year-old that were born in the US, they are US citizens, and the parents cannot go and work because if they go and work, they'll either face enforcement action, arrests, and in fact, they're not even going to be employed because I believe it was 2023 where Florida instituted the law where employers had to use E-Verify, a federal database, E-Verify, and before you employed or when you employed someone, you had to make sure that they had authorization to work. And if they didn't have authorization to work, then you were going to pay a fine of $1,000 every day until you could prove that the workers that you had hired in the state of Florida had authorization to work. So number one, even the employers are afraid or will not hire undocumented immigrants. And so if there's a family and they're starving, then it's likely that the 14-year-old who's supposed to be going to school, sleeping at night, learning, studying, will be the one sent off to go and work while the parents sit at home in fear. As I mentioned, the bill will pass through several other committees, a few other committees before it's finalized and voted upon. So we're waiting to see how that progresses. Yeah, share your thoughts on this new bill that has been proposed that will let 14-year-olds work night shifts. I mean, think about if the 13-year-old, for example, goes to or gets a job at Walmart, a 24-hour Walmart or a 24-hour CVS or even a McDonald's, whatever business that opens 24 hours, and the child is there with a supervisor or a colleague that is 30 years old, let's say a 14-year-old girl, she's there working night shift, supervisor is a 35-year-old man. If he's a private, your guess is as good as mine. I don't know what the employers are going to be putting in place to protect some of these minors and what will be done to make sure that some of these things don't happen. But this is just one of a few, concerns that people have, legitimate concerns that people have about Florida's new bill that has been proposed. Obviously, Governor Ron DeSantis is in full support of the bill. So, yeah. All right. Okay. Now let's move on to the next discussion for the day. Let me take this off and then we can share the screen for that. We're going to discuss the pause on green card applications. Some green card applications, it's not for every green card application on this, this information only applies to some green card applications. So let me pull I think this is it. Okay, there you go. All right, so there is a pause on green card applications. Not all green card applications, just some green card applications, okay? This information was reported by CBS News. CBS News reported this information it has not been publicized. But CBS News, as you guys know, some of the news outlets, they have insiders in the Trump administration or in government at each point in time that give them, they have insiders that give them information about what's going on, what memos have been released, what internal, memos are circulating and whatnot. So CBS News gave us this information, and again, it has not been made public, but according to the report, there has been a pause on green card applications that have been filed by refugees and asylees. Okay, by refugees and asylees. So if you are an asylum seeker, or you were granted asylee status, or you were granted refugee status, these people are people who fear persecution based on their race, their sex, their gender, political view. For refugees, they go through the U.S. Refugee project, usually outside the U.S. They get they obtain a recommendation. Let me see how, they obtain a referral to the USRAP program. Okay, so the U.S. Refugee Admissions Program for consideration as a refugee. Again, they're afraid of being persecuted based on certain things, like whether some people may be bisexual in certain countries that criminalize bisexuality, okay, or based on their political opinion. Once they receive a referral, then they will receive help filling out their application. And you do all of this while you are in your country as a refugee. Then you'll be interviewed abroad by USCIS officer who determine that are you eligible for refugee resettlement. Okay. Now, once you come into the US, obviously before coming, you do a medical exam, a cultural orientation, and then a loan to travel to the US. So when they come in, they already have refugee status. Asylees, on the other hand, they flee from their countries, come inside, and then apply for asylum within the United States. Refugees will apply for protection from outside the United States. So now, once you are granted refugee status or asylee status, if you came in to the US, you fled your country, came into the United States and applied for asylee status, then, depending on how you came in, there's defensive asylum, there is affirmative asylum. For defensive, you came in likely without inspection, no visa, you weren't paroled, you just came in through the border, for example, and you were issued with an NTA, notice to appear. You appeared in immigration court, the immigration judge heard your story and granted you asylee status, approved your asylum case. If you came in with a visa or parole and you were able to apply for your asylum with the USCIS office, then you do have, or you did an affirmative asylum application. And if USCIS or immigration courts grants your asylum application, then you are approved as an asylee, and you wait 1 year, and then you can apply for your green card. Okay, so for these people, the green card applications have been paused, according to the report. Apparently, USCIS, they directed their officials to suspend processing of requests for green cards that have been submitted by immigrants who are granted refugee or asylee status. And this is based on two executive actions, the related executive, the executive actions or the executive orders related to this direction. The first one is protecting the United States from foreign terrorists and other national security and public safety threats. The 14161, that's where the visa screening information is contained, that people must be vetted and screened to the maximum degree possible. If you guys remember, we discussed that right here. The second executive order upon which the pause of green card applications for asylees and refugees is based is the Executive Order 14157, and it's entitled Designating Cartels and Other Organizations as Foreign Terrorist Organizations and Specially Designated Global Terrorists. Okay, so they want to vet and screen to identify potential fraud, public safety or national security concerns, and that's the basis of this. I mean, because usually and that's why people are concerned, because if before you're granted refugee status or asylee status, you're vetted, your background is reviewed, they go through a very rigorous background check. So I'm not sure what else they are reviewing again, but that's the information that we have. This does not obviously apply to all green card holders, just people who are trying to apply for green cards or lawful permanent residency based on their asylee status or refugee status. Okay, now let's move on to the next thing. We're doing an update marathon here, so let's go. Let me take this off, and then we go to the next discussion, which is the CIS ombudsman. The CIS ombudsman office that has been closed down. I shared the story. One of the stories that we've, let me see, hold on, guys. Okay, there you go. Oh, okay, no, this one I don't need to share any screen there, but the CIS ombudsman office has been closed down, and I know that many people don't know what this office does, or I don't know what many of you don't know what this office does or is supposed to do. And the DHS Civil Rights and Civil Liberties, CRFCL, as well as the OIDO Immigration Detention Ombudsman offices, those have been shut down. And so all the staff, apart from some senior executive service staff, have been placed on a 60-day administrative leave. When you are placed on a 60-day administrative leave, it could be due to a restructuring or some internal investigations, or they're just trying to figure out what to do next. Okay. Now the OIDO, that's the Immigration Detention Ombudsman, was responsible for monitoring immigration detention centers, handling complaints. Right, if you are detained in immigration detention or in a facility, and you have complaints, then you could channel those complaints to this agency. The office further helped to ensure that those who were detained were treated fairly and that the facilities met proper standards. That has been shut down. Tricia McLaughlin, who's the DHS spokesperson, she said that they are not in favor of these offices because these offices have obstructed immigration enforcement. They've added a lot of bureaucratic hurdles, and they've undermined DHS's mission. And that rather than supporting law enforcement efforts, they often act or function as adversaries that slow down operations. Again, we spoke about the ombudsman on our social media pages today. And as you guys know, the ombudsman office, it's, very case assistants, they are really phenomenal. They help with so many things. Where USCIS does an improper case rejection or rejects your case improperly, then you can seek refuge or ask them for help. Because sometimes you see that case rejections really can jeopardize your status. For example, if you're trying to change status from, let's say, or no, let me say, first of all, if you're trying to extend status in order to change status, and you file the extension of status, and the extension of status, if you're on a non-immigrant visa, let's say on a B2 visa, and you find that, oh, okay, CBP gave me 6 months to stay in the United States. I came in to go undergo medical treatment, and I've done the surgery, but my doctor says that I need to come for a checkup. Let's say I'm in my 4th month after I entered the US. I did the surgery. Let's say you did a back surgery. You've spent 4 months. You go for your checkup. Doctor says, okay, we want to see you again in 3 months. You would need to file an extension of your B2 visa, your I-94, because you were just given 6 months. Okay, if you file that extension and it goes to USCIS, let's say you file the extension 2 weeks before your your I-94 expires, and it goes to USCIS and they improperly reject it. They send your case, your entire thing you filed, back to you. Then you are in trouble, because by the time it gets back to you, perhaps you may be out of status, meaning your I-94 would have expired and USCIS has not received a properly filed application trying to extend your status. And that's a problem. So that can really jeopardize your immigration status here. So, the ombudsman would help with improper rejections. And sometimes immigration could just reject your application because they'll say, oh, the proper fee is not included, or you're using the wrong version of the form, or you didn't sign something, or the form doesn't include all pages. And sometimes all the pages of the form will be there. You've paid the correct fee, you mailed to the right place. What they're saying may not necessarily be true. So the ombudsman's office steps in as a neutral arbiter and resolves some of these things. And again, I shared on my social media pages, we've had so many times where immigration would say, okay, we sent you a receipt, even the receipt notice doesn't even jeopardize your case. But sometimes if they send a denial notice to a client, the client may never have received the denial notice. And you guys know, if you apply for an immigration benefit and you are issued with a denial notice, you will usually have 30 days within which to appeal the decision, file a motion to reopen, or file a motion to reconsider. They can give you 33 days if you receive the decision, the adverse decision, through regular mail. But if USCIS doesn't send you the decision, then sometimes you wouldn't even know that your case has been denied if you don't have a law firm actively tracking your case. And many people have been screwed because they found out that, oh, my case was denied last year, I didn't even know. And they're completely out of time. Okay, some people will find out 3 months later, oh my God, they had a lot of things happening and it didn't track. And then the US immigration, they just finally tracked and saw that they said the case had been denied 3 months ago. And it's a major problem, because if USCIS denies a case, you should receive a copy of the decision notice so that you can give it to your attorneys or an attorney you retain, and then the attorney can review the basis of the decision, the basis of the negative decision, and then see how they can overcome that decision. Okay, they'll see how they can overcome that decision or see how they can have that decision overturned. And so again, we've had cases like that, and we would work with the CIS ombudsman, and then USCIS would send the decision, because sometimes you will do your e-request, ask them several times to send the decision, and they won't send it. They'll say, oh, we'll send this by this date, and they won't send it, and time keeps passing by. So they've been very instrumental. They've been very instrumental in helping keep USCIS in check. Unfortunately, it's been closed down. So we'll wait to see whether they're going to be, is it going to come back in a different structure, reinstated in a different structure, or will there be new oversight mechanisms, or maybe another agency will come in or step in to fill the gap, or what can we do to ensure ensure accountability for DHS actions moving forward? Obviously, the courts are there, but even now, President Trump is threatening, attorneys that take him to court, take him on, and and again, apart from that, there's also, when you take the government to court, it involves a lot of money. It's a very expensive process, and many, some immigrants may not have the funds or the resources to take the government on, and some immigrants themselves are also worried that, well, if I sue the government, I have a green card case pending, will they not use this against me? So people are very hesitant to take the government to immigration court. So the ombudsman was a very good resource, but yes, now it has been shut down, along with these other offices. So we'll wait to see what other information comes from this shutdown. Okay. All right, now let's look at what's going on with all these student arrests, immigration enforcement actions. It looks like there's a shift. Now they're not really going for dangerous criminals as they had stated. There has been a shift. Let's take a look here. Let me share my screen. I will be sharing the screen from, let me see which document here. Yeah. All right. Okay. Yeah. Let's look at this from one of the news portals. I believe it's Yum. Okay. Let me open this up. Okay. So I know that some of the arrests have been very public and others not really public. Um, so let's look at some of them that have occurred so far. We'll go through a few of them. We don't have time to go through all the arrests, but this person from the University of Alabama, Alireza Dorudu, PhD candidate studying mechanical engineering. I believe he's from Iran. He's been detained by ICE. We don't have much information on that. In fact, a lot of them, there's lawyers are still struggling to figure out why they've been detained. I mean, they later on learned that some of them may have been involved in certain types of activism. But let's go on. Romeza Ozturk, that's the one that had over six. Was it about six? Okay, I think it was about six ICE officers who were like a masked Rambo style detain her. This girl unarmed. I don't think it had to take six masked people to detain this woman. Um, well, she is also, I believe, Tufts University, and according to the report, her visa has been revoked and she's been transferred to Louisiana. The favorite of the government is Louisiana, that detention facility. Louisiana, because it's easy for them to pursue their agenda there. Louisiana, very, the detention centers that are within the jurisdiction of the immigration courts, they barely order the release of immigrants. So it's very easy to have them detained there. There's more detention facilities also there. I believe apparently Texas has the biggest detention facility or beds, and then Louisiana is next. They have a lot of beds and detention facilities there. So they have space to house all these people, and they can be sure that the judgment would usually go against the immigrants. So that's why they're transferring them as a strategic means of, okay. So, yes, the student visa has been terminated. Then the French researcher, she was coming in and she was texting people, criticizing Trump. And these text messages, she was coming in on a conference. I believe it must have been a B visa, and they detained her, found these text messages, and they deported her. Put her in expedited removal or returned her to her country. You want to be aware, and one of the things so if you have things on your phone criticizing Trump, and you're coming in on a non-immigrant visa, then you want to be aware that there could be consequences. Okay, if you criticize him and they find it on your social media, on your phone, then you could be put in expedited removal, I guess, depending on the nature of the criticism. Another thing to note is that it's not just about people try to avoid this by turning off their phones when they're coming in. If you turn off your phone and your phone has a low battery, then you risk having your phone seized, so that they'll charge it and review what's on it. So you're better off fully charging your device or just leaving them at home or in a safe place before you try to come into the US through a port of entry or any other, such as an airport or land port or whatever. They've been, cracking down on people who have all these things on their phones. If you are, supporting Hamas, or you are supporting any of the groups that have been designated as terrorist groups, then you could be arrested if you're already in the United States as a student and your visa could be terminated. If you're already in the US, you're a green card holder. This is what happened to Mahmoud Khalil. Then they'll detain you and take you through deportation proceedings. Okay. So, guys, remember that depending on where you are and your immigration status, that's how they are going to determine what they need to do to you. If you are a non-immigrant, you have a non-immigrant visa, like an F2 visa or an F1 visa, and you are coming into the US and they find information, derogatory information, like where you're pro-Palestine, you're supporting Palestine, you're supporting Palestine, then they could deny you entry into the United States because you don't necessarily have a right to be allowed into the US. It's a privilege. It's always been a privilege as a non-immigrant visa holder to be allowed entry into the US. And people say, "Oh, the visa is like your concert ticket." Okay, and when you get to the concerts, then they'll determine whether they'll let you in or they'll bounce you. Okay, so visa, it doesn't guarantee you entry necessarily. They'll review and make sure that you are coming in, you don't have a gun on you, you're not trying to hurt anybody or whatever. Now, if you are on a non-immigrant visa, you're already in the United States, then they have to take you to immigration court before you can be deported, because Fifth Amendment rights, you are, your life, liberty, property, you cannot be deprived of them unless there's due process. If you're a green card holder, you are coming into the US and you are suspected of activism that the US government does not approve of, then you will be allowed to enter the US, but you could be sent to immigration court because you are deportable or because you are inadmissible, if you are determined to be inadmissible, right? As a green card holder, you have the right to enter and see an immigration judge. If a CBP officer thinks that you are not entitled to your green card, they cannot just take your green card unilaterally. There's that there. So depending on your status. All right. So Mahmoud Khalil, green card holder, has a pregnant wife, and he was arrested because he was, according to ICE, supporting Hamas. He was involved with the pro-Palestinian encampments at Columbia University last year, and I believe they're still waiting for his court hearing. I know there was a transfer of his case from Louisiana to New Jersey. There's a lot going on. But yes, if you are here, we won't go into all. Yeah, Dr. Rasha's case was also very highly publicized. Lebanese citizen. She had an H-1B. That's a work visa, allows you 3 years in the US, and then it can be extended for an additional 3 years. She was a kidney doctor, or she is a kidney doctor, and I believe she at Brown, she was working in Brown University or studying and researching, and she was detained at Logan International Airport, Boston Airport. She had apparently gone for the funeral of Hezbollah, a Hezbollah leader. Hezbollah is designated as a terrorist organization, and so unfortunately, she was denied entry. This exemplifies exactly what I'm telling you. So there's a lot of confusion, but you will be denied entry if you are on a non-immigrant visa, like H-1B, F1, F2, J1, B2. But if you're a green card holder, they'll let you come in and then you go through immigration court. If you're already in the United States, you go through immigration court. Okay, you cannot just be deported without going through immigration court, unless of course you go through, they're doing expedited removal or administrative removal or some other type of removal. All right, I think it's a good time to see if we can. Let me actually add. I was going to do questions, but let's take a look at this information. I saw this very, very interesting information that was shared by NAFSA on how much the US benefits from international students, and I found it. I found it really, really interesting. At this time, already the US is becoming unattractive to many international students. I mean, each country has to do what they have to do, right? They have to, and if you're a foreigner coming into the US, you have to make sure that you are not necessarily violating their laws, because if you do, there are consequences. But the problem is that the way in which it's being done is acting as a deterrent for many students. Now, if you look at my screen, maybe I should zoom in a little bit more. I'm going to show you guys this information. So there's a research that was done by, yes, NAFSA. And so there are over 1.1 million international students in the United States. Well, as this research was done for 2023-2024 fiscal year, over 1.1 million international students, and international students are bringing in or raking in, contributing over $43 billion to the US economy. And they are supporting over 375,000 jobs in the US. For every three international students, one US job is created, okay, and supported by spending or caring, because these people, international students, are admitted. They're paying tuition, they're paying accommodation, dining, retail, transportation, telecoms, and health insurance. And so international students bring in a lot of money, and as much as possible, the U.S. government wants to look at the way in which it's conducting some of these arrests and detentions, so that it won't scare off. Because if you look at some of the policy changes from 2 years ago, 3 years ago, USCIS, even the government said they want to retain the brightest and best from around the world. They want to retain the best talent, EB2 and IW. They are trying to make sure that these brilliant minds come into the United States and contribute their quota to the US economy. Okay, so these kinds of things could certainly scare them. Look at all the stats. It's been broken down by state. Now, let me tell you which states have the highest numbers of international students and how much they're contributing. International students are contributing to the US economy from these states. Let's see here. Okay, so the 5 states in 2023-2024, according to statistics, that saw the largest amount of economic activities in the United States. Number 1, California. Drum roll, California. Let's see, California right here. $6.4 billion. That's how much. That's how much California contributed to the US economy. Okay, this is their benefits of international students. California contributed $6.4 billion. The next state is New York, almighty New York. The international students contributed $6.3 billion. Third is Massachusetts, $3.9 billion contribution by US and by foreign students into the US. Fourth is the state of Texas. They contributed, let's see what the dollar amount that international students brought into the US, $2.5 billion. Students in Texas from around the world. And then Illinois, state of Illinois, the students brought in $2.4 billion. So look at how much the US benefits from international students. So it's important that they reevaluate what's going on with the arrests and the detentions, so that we can keep attracting the best and the brightest from around the world. Okay, now let's look at a very interesting story. This is the highlight of this live video. Stay tuned. We're going to be discussing something so exciting, very interesting story. It's about a woman called Vizgera. I know many of you haven't heard about this story, but we're going to go into it momentarily. Let me stop sharing my screen. What's going on here? Oh, I don't know if you guys. Oh, it looks like the screen was already. Okay, well, they stopped sharing the screen. The NAFSA Did you guys see the screen though? Please confirm YouTube, Facebook, LinkedIn. It looks like the screen went off. So I'm not sure what happened there, but confirm if you saw the story about Vizgera. Okay. I don't think I'll be able to share the screen there. So let's just talk about her here. Now, Vizgera was just recently arrested. Okay, she was recently arrested. Who is Vizgera? You'll ask. Who is Vizgera? Vizgera is a Mexican woman. She's called Janet Vizgera. She's a mom of 4 children, undocumented, and she came into the U.S. I believe in '97. She came in from Mexico in 1997. She's been living in the U.S. undocumented since that time, and she has, I believe, 3 American-born children who are under the age. Oh, okay, this was in 2017, but I believe she now has 4 children. 2017, she had 3 American children, U.S. citizens. And what happened was that Vizgera, when Trump came into power the first time, she guess what she did, guys? She actually ran to a church, the basement of a church, to seek refuge from deportation. If you guys remember, the church, there was a memo on sensitive locations where ICE could not carry out enforcement actions, churches, schools, hospitals. And so this smart woman, well, forward thinking as a mom would do, any mom would do, she ran to a church basement in Denver and hid there with her children. And that's where they had been living for several years. And so she became a symbol of resilience for the world. People were just so impressed about what she had done, just running to a church and living there at the basement, taking advantage of the sensitive location policy, and then refusing to get arrested. She was actually declared as one of the 100 most influential people in the world. Times does this because of what she had done. She was recognized as one of the world's most influential individuals. Now, the twist is that, fortunately for ICE, unfortunately for her and her family, ICE just arrested her again in 2025, in March, just about a few days ago. Well, I'll say a week ago, Vizgera was unfortunately arrested, and she was caught near Target. I believe she works in Target, or she was caught outside Target, and then ICE caught her and said, "Finally, we've got you. We finally got you," because they had been looking for her since 2017, but she had run to the basement of a church, and her story was publicized, and people found inspiration and hope. People who had come into the US undocumented, and were not criminals necessarily, but were coming for a better life and had families trying to stay in the United States. They found that she was the symbol of hope for them. ICE now has her. ICE has arrested her. Okay, now she has 4 children. She has 4 children now. And she's been taken to immigration court, and a federal judge has blocked her deportation already. So we're waiting to see how Janet Vizgera's case is going to proceed. And, so again, there's a shift in immigration enforcement. Some of the comments are making me laugh. Okay. There's a shift in immigration enforcement. So you guys, I hope this has been helpful so far. Let's take some questions from TikTok, from Instagram, from Twitter. I see some comments. Somebody says, "I like the way you talk." Prophet George Clotte, thank you for joining. Okay, so let's see on Instagram, any questions that you guys have, drop them in, what we've discussed. I'm getting several requests to join in the live video, but we can't do that today. Let's just see if we can answer questions so that people... Oh, okay. Somebody says, "We hear you, but eventually you'll need a better microphone." Okay, I'll take note of that. I do have, okay, I'll try to use a microphone. It looks like maybe there are some echoes. Okay, so somebody says here on Facebook, let's see this. Sri Lanka JR Warden says, "Hi, I think travel ban is media rumors. There's no travel ban, surely." Tilanka is connecting from Facebook. I don't know if I'm that confident that there's no travel ban, surely. But yes, I believe Secretary of State has come out to say there's no list. That list, that rumor is not true. New York Times came with a draft list. They said, nope, not true, false information, but they are reviewing countries according to the Executive Order 14161 to determine which countries pose a threat to the security of the United States. So again, we're waiting to see what Trump travel ban 5.0 will look like. We've had 1.0, 2.0, 3.0, 4.0, 1.0 struck down, 2.0 struck down, 3.0 was upheld by the court, 4.0 expanded, 3.0. So we wait to see. I don't know if it's for sure that there's none. I suspect that there is going to be some travel restrictions for people from certain countries. I will wait to see how that goes. Don't be too confident in the fact that there will be no travel ban. I don't think so. Okay, so Grace Favor on TikTok says, please, lawyer, how long should I have to wait after divorce before I can marry again? Okay, I'm not sure what the purpose of your remarriage is, right? If you are in Ghana and you are trying to get married again after divorce, then that's not U.S. immigration related. But if you are trying to apply for a U.S. immigration benefit through your new marriage, and you're asking this question, I mean, there's no law that tells officers that, oh, if you get married a day after your divorce, your green card application should be denied. Not necessarily. It just depends on the situation. Some people separate for 3 years before their divorce is finalized. So once the divorce is finalized, they are ready to get married the next day. That's fine. It depends on what really happened. So this, I would say, contact us to see, especially if you have a U.S. immigration case that you're looking to file, and then we can look at the particulars of your case and give you the advice that is needed for you. Okay. I applied for citizenship 3 weeks after I applied to renew my green card. Will this affect renewal? This is Mike on TikTok. Well, you should not have applied for your renewal if you knew you were applying for US citizenship, because when you apply for US citizenship, you will, in 3 weeks, so if let's say you do the naturalization process N400, you'll get a receipt notice after 3 weeks or after a month. And the receipt notice will extend your green card for additional time. I believe it was extended to 24 months for the N400 receipt notice. So if your green card expires, then you can use the N400 receipt notice as evidence that your green card is still valid, even though it's expired. Okay. So you've just, in essence, wasted some money because, yes, this update was end of 2022, where they updated the policy to extend your green card for 24 more months if you apply for naturalization. So you didn't have to renew your green card at all. You just wasted money there, but I guess that's okay. It won't affect the renewal. If you do get your citizenship before the renewal, then you would have to try to file a withdrawal of the renewal. So you can contact us to see how we can help you in that event if your green card or your US citizenship case is approved before. Because the thing about renewing your green cards to the I-90, it takes so many years. Like, it takes a long time. Some people get it really quickly. Others, sometimes after 2 years, 18 months, it takes a really long time. So, all right. My Paddy on TikTok says, I filed I-130 for my daughter in the UK in 2023, but it's still not out. Any advice, please? Depends on your status, petitioner. Petitioner, are you a US citizen? Are you a green card holder? Is your daughter married? Is she unmarried? That will determine the category, right? So we have immediate relatives are spouses of US citizens, minor children of US citizens, and parents of US citizens. Those people, there's no wait time, so it's usually shorter. Then we have the preference immigrants category. F1, we have married children, adults, children of US citizens. F2A, we have spouses of green card holders, minor children of green card holders. F3, F2B, we have adult unmarried children of green card holders. And F3, we have children who are married, adult children of US citizens, and F4 siblings. So if she's F2B, F2A, immediate relative, F3, it depends. That will determine what the processing timelines are and what's her priority, that will determine processing timelines, I would say. I'm sorry, let's see. Guys, don't forget to follow and like our page. Okay, Christiana Pickens on YouTube says, for an I-130 case that has been filed since 2007, and I keep getting the same email for interview dates, with lawyer involvement speed up the process. The thing with these cases that are taking so long, if it's a preference immigrant case, the problem is that if there's an issue, you'll wait for 15 years, 16 years, only for the case to get denied, and you've wasted all that time. So, for the way the cases take so long, especially for these F3, F4, I don't know if that's an F4 category case. It looks like probably F4. Sibling of a US citizen, perhaps. It takes you a really long time that you want to make sure the right thing is done. And those are some of the things that help speed up the process, right? I don't know if the person is documentarily qualified, it depends. But yes, it can help because we know what we're doing and we can try to, make sure that the right thing has been done and you haven't done anything that can delay your case. The lawyer cannot necessarily, just because there's a lawyer, just expedite the case, but there's other ways to make sure that there are no delays in your case, ensure that the right thing is being done pretty much. Okay. All right. Okay, yeah, she's asking Christiana, how long should I wait after an interview date since all documents have been approved? Again, it depends on, so it looks like you're doing a consular processing. Consular processing means that the petitioner is in the United States and the beneficiary is outside the United States. And consular processing, you start with USCIS, you do the first part, second part, National Visa Center, where you have to submit documents, and then if it's approved, you're documentarily qualified. And then depending on your priority date, you'll be scheduled for an interview. So depending on your category, the priority date, and visa bulletin movement, as well as documentary qualification dates, that's all these things affect how long you should wait after documentary qualification. Okay. So I have a question from Gloria Angel on LinkedIn. I'm on an F1 visa. I am an F1 visa holder, but my family has a green card and want to know how my dad can file for me. So yeah, your dad can file an adjustment of status case for you. Depends on whether you're well, if you are unmarried, he can file under the F2B. And the problem is that F2B visa bulletin, you have to check, let's see, adjustment of status chart, how long you have to wait to be able to get a green card. And that means that you have to stay in status. You have to stay in status until a visa becomes available for your case under F2B, and then you can apply for your green card. You cannot fall out of F status. So you have people who, keep learning until a visa becomes available. Obviously, some people are really pursuing their They are really pursuing an academic dream. Okay, so I'm going to look this up for you, the F2B adjustment of status chart for March 2025. Let's take a look. If you are in the United States, F2B dates for filing charts, they are in 2030. Oh no, they are in 2017. So that's about an 8-year backlog. And then for final action dates charts, let's see here. Yeah. So there's a lot of delay in these processing, and you'd have to maintain status until a visa becomes available. So they can file for you, but Gloria, it depends. It depends on so many things. How long does it take for a student to stay in status? It depends on you, your I-20, your CVIS record, and what you are studying. For some people, they're doing a PhD, so 5 years, 4 years. Other people is just a bachelor's degree, so maybe 3 years, 4 years. Others is a master's degree, 2 years, and you have to maintain your, an active CVIS record by following all the rules, paying your fees, attending your classes. So once you are doing all those things, then you continue to be in status. Okay, so yeah, feel free to give us a call so we can discuss your case and see how we can help you. All right, let's see here. Let me see. Let me read at least a question from Instagram. We haven't read anything. The Instagram is Macaron Chakaron on Instagram says, is there any hope for those with visa overstay? It depends. It depends. Usually, those with visa overstay, they are able to adjust their status in the US through marriage or, usually through marriage to a US citizen or to a US citizen if they get one, or through some other family, like they have a child who's above 21. They can adjust their status without having to leave the United States. If you came in without a visa, then it's more difficult. So that's one of the routes for those with visa overstays. All right, guys, I think that we have done quite a lot today. So thank you so much for joining in. Hopefully we'll be live again next week. Please follow our social media pages. And if you've enjoyed this live session, please drop USA in the chat box. Give me a thumbs up. Give us a thumbs up. Let's see that you benefited from this session. Follow our pages across social media, AK Pokolo. Share the live feed and give us thumbs up before we hop off. And in the meantime, let me see if there is a final question that I can answer while you guys give us the thumbs up and we round up. Nanaja 24 on TikTok says, my I-751 application has been pending for 2 years. As I am still in a valid marriage, am I eligible? Eligible for, to apply for US citizenship. Yeah, if you've been married for, you've been a green card holder for at least 3 years and you are married to a US citizen, then you can apply for citizenship under the 3-year rule. You don't have to wait for your removal of conditions application to be approved before you can apply for US citizenship. In fact, it's a strategy that we use to push along the removal of conditions. Removal of conditions also takes so long. It takes so long. It can take this. So when you file the removal of conditions 751, they give you a 4-year receipt notice that extends your green card. Okay, that extends your green card, and so that takes a long time. But while you are waiting, you can still apply for US citizenship. And somebody says, what is petty offense exception for citizenship? It's usually for green card application. If you commit a crime involving moral turpitude, and it's just the sentencing was less than 6 months, was less than, I believe, 1 year, and your actual sentencing was less than 6 months, and it's your only offense, then you could get the petty offense exception so that you are not inadmissible under criminal grounds. So it's usually if you have a CIMT and you are inadmissible, a crime involving moral turpitude, and you are inadmissible, and you are trying to apply for a green card, and you fall within this petty offense exception, then you will not be found inadmissible anymore because you have the petty offense exception. Okay. If you have an inadmissibility, you cannot get a green card. And so you either need a waiver, or if you fall within the petty offense exception, then you are not inadmissible anymore. Let me see. Yeah. Actual punishment imposed was less than 6 months, and the crime itself was not more than, I believe, 1 year of imprisonment. All right, guys, thank you so much. Drop the comments if you benefited. Give us a thumbs up. Recommend us on social media, and follow our pages. Share the feed. Drop comments. Let me see that you guys have enjoyed this live session, and we'll be with you again. Oh, thank you so much. Kobina Abaka says, great job, Ikuya. Thank you. From Mr. Francis Gabin says, thank you also. Lawyer Ikuya, thank you. Christiana Pickens says, thank you. Thank you so, so much. I really appreciate all the feedback. It encourages us to do more. So drop at least USA, and then we can hop off. I'll see you guys hopefully soon. And in the meantime, stay safe and bye.